Judicial Education Program Specialist Anne-Marie Mayu.
Today we have some special guests from the Nevada Department of Indigent Defense Services, or DIDS, the Executive Director, Marcie, Ryba, and the Deputy Director, Thomas Qualls. Welcome to you both.
Thank you.
Thank you.
Just a little bit of a historical background. In 2019, the Department of Indigent Defense Services, or DIDS, was created, and part of the reason that we were created was the ACLU sued the state of Nevada. They were saying that we weren't protecting the Sixth Amendment rights of our indigent defendants in these rural courts. So they created the Department of Indigent Defense Services, and they statutorily required us in NRS 180 to complete certain things that we had to do. There was also a stipulated consent judgment that was entered, and that also had a timeline that we had to complete certain things. And just examples of what we're doing are we were required to collect data. We're required to collect data of how many cases our public defenders have in these rural counties and how much time that they're spending on these case types. We also had to create a registry or collection of attorneys and create standards to ensure that the qualifications of the attorney match the challenges of each of the cases. So we've rolled out regulations to address all of these items. Tom, did you want to add anything to that?
Sure. There's checklists of what we're supposed to do as far as providing training, setting standards, and supporting indigent defense practitioners across the state. Our mission, in a nutshell, is to create sustainable and effective indigent defense systems, otherwise known as public defender systems throughout the state. Each county is in charge of its own plan, its own way that it wants to provide public defender services. They can create a county public defender office, so an institutional office, just like a district attorney's office, or they can contract with private individuals, private defense attorneys to provide those services, or they can opt in to the state public defender's office to provide those services. So what we've done is we've traveled around the state and we've talked to judges and county managers and practitioners, and we've observed court, and we're sort of working on specializing services in each county according to what the needs are, what the population is, what is possible there. One of the best things about the system is that the state agreed to help the counties in building these more robust and sustainable systems. So there was a maximum contribution cap set, and the county only has to pay up to that cap for public defense services, and anything that they spend over that in trying to comply with these regulations and create these sustainable systems, they can ask the state for reimbursement for. And so far we have gone through how many rounds of reimbursements? How many quarters? 3?
Last year, in the last fiscal year, we reimbursed over $1.9 million for our rural counties. So every county that met its maximum contribution was reimbursed by the state. And I think there's a misunderstanding there, because when I mentioned Davis at the beginning of this discussion, there were certain Davis counties that were specifically listed as parties. And in short, those were the counties that relied on contract attorneys to provide indigent defense services. So a lot of people had a misunderstanding that we were only reimbursing those Davis counties. But in fact, we're reimbursing all rural counties that have met their maximum and requested reimbursement. Most counties reach their maximum by the fourth quarter. Some counties reach it in the third quarter. So we reimbursed all last year, the $1.9 million. This year, we've reimbursed a couple of counties that have met their maximum so far. And then fourth quarter reimbursements are coming up, and we expect to be able to reimburse everyone that's hit their maximum for the full amount. And part of that is based on, in this legislative session, we received a supplemental appropriation of about $2.6 million so that we could make all of these rural counties whole.
Just attached to that, we can talk more about our successes at the legislative session this year, but we have been allocated $7 million for the biennium, so $3.5 million for each of the next 2 years for these reimbursements.
And I think the the maximum contribution formula, when you look at NRS 180, it said that the board had to create a regulation to adopt it. So we did that. But most recently in this legislative session, the legislature actually put it in statute. So the maximum contribution formula is there, and it says that we will be reimbursing these counties once they reach their maximum. And there's also an allocation that if we run out of funding to be able to pay for these, if that $7 million is insufficient for the biennium, we need to go to the statutory contingency account, and they must provide that funding to reimburse our rural counties.
In simple language, when we started this, there was a lot of reluctance from the counties to do anything they didn't have to do, or to build these, extra things into their systems, because they didn't believe that the state was going to come through with reimbursements. But not only have we come through and fought for these reimbursements for Davis and non-Davis counties through the IFC, but now the money is actually in our budget, so we don't have to go through a third party for reimbursement. And as Marcie mentioned, there's a statutory provision that says even if we run out of that money, the state still has to bring contingency funds to the table.
So do you know how many counties you've actually been able to reimburse at this point?
So we oversee 15 rural counties. Everyone that hit their max in the last fiscal year got reimbursed, and I think it was 9 counties.
Wow.
Yeah, and I think what we're seeing is those counties that got reimbursed made big changes to their indigent defense systems. Churchill County, for example, switched from a contract public defender system to creating 2 separate public defender offices and having a third contract attorney and a council administrator all within the county. So all of those extra expenses are being reimbursed. Other counties that haven't made much change, they didn't meet their maximum, because the maximum contribution formula was based on what you spent in fiscal year 18 and 19 plus inflation. So if you don't really change anything, you're not going to exceed it. And that's why I think counties were hesitant to make the changes, because there's a question of whether they would be reimbursed. And we're trying to show them we've reimbursed, so now let's make the positive change.
Right. That's great. Well, it sounds like Churchill County would be a good resource for any of the other counties that are looking at maybe making changes.
Absolutely. Churchill County has done a fantastic job in pivoting and adding layers to their system.
That's great. Now, the reimbursement process, does that take a long time, or is it pretty quick?
The reimbursement process at this point was a little slower, because in 2021, when we had our legislative session, COVID was in place, and almost every state agency asking us for cuts rather than increasing funding for the maximum contribution formula. So we didn't really know how much funding we needed for the maximum contribution formula. The state of Nevada didn't really know how much money they would have because of COVID, and who knows what the future was going to be with that. So they didn't actually place the money in 2021 in our budget. What they did instead is they set aside funding in the statutory contingency account, and we had to go to interim finance to ask for that reimbursement. So in this past fiscal year, it took a couple of months, because we had to get on the interim finance calendar. We had to get these items approved. It was the first time going with this reimbursement, so we had to make sure everyone was on the same page of how we did it. But ultimately, every county got reimbursed that met their maximum. In this current fiscal year, because we received that supplemental appropriation, we expect reimbursement to happen a lot more quickly, but we still have some of those funds that are set aside. So we're going to be going back to interim finance in August to request the remaining $499,000 approximately. And once we receive that, if approved by interim finance, then we will start the distribution process for all counties. And then going forward in the next biennium, because the money's in our budget, once they prove that they've reached their maximum contribution. And this is done by the county submitting fiscal reports showing what they're spending on indigent defense services. And we have to go through and make sure that that is actually indigent defense service expenses. And once they can show that, once they hit their maximum, the reimbursement process will be much more quick. If you read our regulations, it talks about the process where it's quarterly reporting. And then when you tie that with the statute of annual reporting, what we've done is we've gone to these counties face to face, and we've talked to them and we've explained the process. And I think that's been the most helpful, because in some of these smaller counties that don't have much county staff, when these reports are due, I generally just call them and walk it through with them to make sure that they're getting these things done correctly. But generally, we have our contact point for each county. We send them a reminder email that this quarterly report is coming up. If we haven't received it in time, we send them another reminder, and then sometimes we just start the phone calls. So I think what's been really important to us is really making that face-to-face connection, which was a little hard because our department was created in 2019 and COVID happened shortly thereafter. So that was one of our biggest hurdles at the beginning, was just COVID. But once we were allowed to start traveling, Tom and I got on the road and we went to as many counties as we could go to, just because it's so important to meet face-to-face with these individuals.
Awesome. That does really make a big difference. So why don't we talk about some of the challenges that you have faced so far?
The number one biggest challenge is a challenge all over the nation right now, and that's that there's a crisis in the shortage of public defenders in Nevada, especially in the rurals. We talk about squeezing the balloon. We send them over here, and then this county's short. And a lot of times judges are not aware of the work that goes on behind the scenes to make sure that there are attorneys in their courts for all of these cases. There's hundreds and hundreds and hundreds of these that we deal with on a monthly basis, because our department serves as what's called like a appointed counsel administrator. So we make sure that if the public defender's office has a conflict, we appoint conflict counsel and make sure that somebody's covering that case. We also
technically select. It's the judge that appoints,
yeah,
right?
Yeah, sorry, there is a semantics there. The judge appoints, we select. Anyway, I could go down that rabbit hole, but the biggest problem is a scarcity of public defenders, and we're working behind the scenes in a number of ways to help that, including working on pipeline programs through UNLV Boyd School of Law, trying to recruit from other states, working on increasing salaries so that they're more competitive, and our board's about to take on the task of increasing the hourly rate for those appointed attorneys. There's a few other things in the works that we're working on, because you can't just create attorneys out of whole cloth. But again, just like in doctors and nurses and public defenders across the nation, we're seeing shortages. So that's probably the number one issue. The second issue, which is close on its heels, is misinformation. There was a lot of, scuttlebutt when our department was created, that this was the state that was looking to just come in and take over, operations in these counties and control everything. And that's not at all the case. It's going to be more bureaucracy. It's going to be whatever, and the state's not going to pay. We've already gone through the fact that the state is keeping their promise and reimbursing these rural counties and allowing these services, which are really not just, about criminal defense. Public defenders do a whole wide range of things, including social work and, addressing all kinds of issues in family and poverty and substance abuse and mental health issues. And, there's a whole wide range of services that public defenders have their hands in that affect the public safety in each of these communities. And so we're really happy about the fact that we've been able to bring more money and resources to that. We're also, we're trying to make all of these systems better so that these communities in which they exist will be stronger and healthier and more robust. So that's the biggest thing, is the misinformation that we're having to counter. But again, our traveling roadshow, as I call it, has been really helpful. It's really great to be able to sit down in a room with people and explain to them and answer their questions. And suddenly, they have a little bit of the same insight into what we do.
And I think another misinformation was questions like, why are you making the attorneys track their cases? Why are you making them keep their time? And not only is this required by the statute, but it's also part of that Davis stipulated consent judgment that we have to do. And ultimately, the end goal is to create a workload recommendation for our public defenders, because we want to make sure that they have sufficient time to be able to handle the caseload that's given to them. And if they don't have sufficient time, then we need to work on increasing the number of attorneys in those counties. So at our next board meeting, in addition to discussing the hourly rate, which is going to move from statutory for these appointed indigent defense attorneys in the rural counties to regulations set by our board, we're also going to be creating a workload and a determination of how many attorneys are needed in each county. So that's why it's all kind of a big picture coming together. But when you look at each piece, it does add a lot of time for the public defenders to have to track their caseload and their time when they already have so much they have to do. And we understand that. But ultimately, the end goal is to try and say, how much time do you actually need for these things? How many people do we need? Because we'd like it to be a job, a public defender job. We'd like it to be something that people want to go into this lifestyle, that it's not you're working all hours of the day and night and weekend just to get your caseload done. We want it to be something where there's that work-life balance, yet you're still giving that representation to these indigent defendants of what they deserve. So it's kind of like the whole balance is our end goal.
Yeah, that's part of the sustainability piece is, information is power. So collecting this data, which has never been collected before in Nevada, we don't have case counts. We don't know how much time people spend on cases. We don't know how many attorneys any county needs in order for the caseload to be sustainable and effective. And so, that's the end result is when these workload standards come out, then attorneys will see their caseloads go down and hopefully their salaries go up, and that's a win-win for everyone.
And I would imagine that these cases are pretty intense emotionally.
Absolutely.
Okay.
I mean, Marcie and I both spent a long time doing indigent defense work. Marcie in the state public defender's office and myself in private practice, but doing indigent defense work both in the state and federal levels. And you literally have people's lives and their future in your hand every day, all day long. And traditionally, it has been an overworked and underpaid job, and we're trying to change that.
I think it didn't help that we were created right before COVID happened, because as a result of COVID, I think a lot of individuals that were practicing indigent defense services left the profession. I think some didn't want to go to jails when COVID was happening. Some were close to retirement and decided that they were just going to, retire at that point in time. So when we do our traveling roadshow and we talk to some of the judges, one question that they always have for us is like, I don't understand why, we have to go through you now, because Assembly Bill 480 kind of created some separation, reduced the workload of our judges by saying it's not up to you to have to select these counsel when there's a conflict anymore. It can come to our department. We'll create lists and we'll help supply attorneys for these cases. And they said, historically what I'd do is I'd just call this attorney down the street, and now that attorney doesn't want to take these cases anymore. So why is this bureaucracy here? We do understand that there are some attorneys that don't want to join our list, that don't want to provide these services, and that's their choice. If this is an attorney that the judge would like to see, please encourage them to join our list. I mean, positive things had happened as a result of, a joint voice of these public defenders. Right now, the hourly rate, according to the statute, is $100 an hour. Because there's that shortage of attorneys, we've reached out to the local counties and they've actually increased the hourly rate. So in some of these counties, they're paying $150 an hour to get these attorneys there. So this is something that hasn't been raised in so long. And just with this positive movement forward and uniting the voice, we're actually able to make this change that we didn't have that ability to do before. And going to the table at the legislature and being a voice for indigent defense, there was no voice before. The state public defender was within the Department of Health and Human Services and never got called to the table to submit bill draft requests or anything of that point. I think just kind of an understanding of we are working towards the sustainable goal. These individuals that may no longer be practicing indigent defense, that's a choice that they're making. They're welcome to get on our lists. And we're hoping that when we make these positive changes, that we'll start to see people understand why we're doing what we're doing and be open to coming and taking on this casework again if that's what's preventing them from doing it.
Yeah, I would just tack on to that for a very long time, prosecutors across the state have enjoyed coalitions and joint trainings, for prosecutors across the state. They have a cohesive group where they share information and resources and training. And that had never been the case for public defenders until our department came along. And we have, the first year because of COVID, we did it virtually, but the last 2 years have been in person. We have had trainings in which not only are they for everybody, all public defenders across the state, but we actually pay for the travel and the room and board of rural attorneys to come to these gatherings, not only get training, but create connections with other public defenders across the state where they have access to daily resources, people that they can call and ask questions and, have you got an expert for this or that? So we provide these valuable trainings that are also really valuable networking and, relationship building exercises. So we have this strong network and kind of cohesive group now of public defenders across the state. And I think that's a huge step in the right direction because you don't feel like you're alone out there anymore.
And following with that, Tom, I think my favorite part of our most recent training is we invited the public defender leader or a leader from each community to come to lunch. And we all sat at one table, and most of the public defenders didn't know each other, even though you had the leader of the Elko Public Defender Office didn't know some of these other leaders in these other offices. And it's like for the first time, we had everyone sitting together at one table, talking and building those connections. And ultimately what we'd like to do is continue to have those discussions of, can we work together as a group of addressing all of the issues that these different public defender offices are having? Because some are different issues, but a lot of them are the same. And if we can work together to create these solutions, that's the best thing we can do. But it was just such a fun lunch to see for the first time. And you're sitting there like, why has this never happened before? All of these public defenders aren't getting together. And it happened for the first time this past training.
Yeah, we did a similar thing with dinners. We made reservations in 3 different places. We had it at the Silver Legacy here this year. We made reservations in 3 different places, and there was anywhere from 10 to 14 people in each location, all sitting down and breaking bread together and just telling war stories and sharing information and just, building bonds. It was really rewarding.
One of the reasons that we produce these podcasts on judicial education is to extend public access. If you're listening and you're enjoying this podcast, you can help us with that. If you would just pass this information on to someone that you know and encourage them to listen in as well, we would appreciate it. Thank you. You have actually a lot of great stuff going on. And is there one particular success that you would like to share with us?
Yeah, I would just say that our greatest success most recently is this legislative session just as a whole.
Sure.
And what Assembly Bill 518 did is it put in statute the maximum contribution formula so that we know what it is and it's going to be set in stone for all of these counties. Even urban counties can opt into the maximum contribution formula. The other great thing about Assembly Bill 518 is that it set aside a little over $14 million. And what the purpose of that $14 million is that we can go to interim finance and ask for more funding if we need money for training. It was pointed out by our Davis monitor that the prosecutors still are receiving more general fund from the legislature for training than our department is. So we're able to present a request for increasing our training amount. Funding is set aside to comply with Davis requirements, and one of the biggest requirement that we touched upon is the workload study. Once our board adopts the workload study, we have to work with each county to comply within 12 months of that adoption. And likely that's going to increase the number of attorneys that are needed for each of those counties. And so there'll be money set aside to be able to pay those attorneys that are coming in.
One of the biggest challenges that we have is that we're tasked with oversight in every county and every court. We're supposed to actually oversee every attorney providing indigent defense services in all of these courts. Well, there's 3 of us directors. Marcie's the executive director, and there are 2 deputy directors. I'm in charge of oversight, basically. And as you can tell just from our brief conversation here, we have a lot on our plates, and we have a lot that we've been doing, and we were so busy many times a week at the legislature this last session, as well as all of our other duties, that the oversight piece is really hard for us. Most of the traveling that Marcie and I have done has been relationship building oriented, although we have overseen courts and met with attorneys to get their feedback. What we really need is more staff to be the primary boots on the ground out in the field doing this oversight work. And so there's funding for that, we're going to need state cars, we're going to need people, we're going to need equipment to go out and do this work. Really, we probably need about 12 people in the staff, but we're going to start slow with 2, I think, and then just go from there. That's a lot of the Davis compliance stuff, is the workload and the oversight and the training.
And then the other nice thing that happened with that are Senators Harris, Senator Scheibel, working with Mary Walker. She prepared a plan where, with the requirement of the 48-hour hearing, which was modified a little bit in Assembly Bill 424, there was concern that this was causing burnout for not just the public defenders, but the district attorneys and the judges as well. There wasn't any sort of relief to provide any sort of coverage. So Mary Walker, working together with these senators, kind of created a proposal to provide a stipend of $450 for each of those weekend appearances. And she created a plan of how much funding each county would get. She proposed an amendment to our bill, Assembly Bill 518, and that fiscal note was added into that bill as well. And the beauty of that is the funds were placed into our account to distribute to each of the counties. The public defender funding was kind of set aside because if they were with the state public defender, we would pay that through payroll, or if they needed us to pay it because they're a smaller county, we could assist with that. But at this point in time, we've paid all of the counties that funding, so they will have that $450 to pay the stipends for our justice of the peace or municipal court judges, the DA, and the public defenders that are appearing at those hearings. And I think, our push towards that, or our support of that, is the system as a whole is something that we're supporting to be more sustainable as well. And with these requirements of the weekend hearings, that is creating that extra workload. So anything that we could do to alleviate some of the concerns of the judiciary, the DA, or the public defenders for that, we are fully supportive of. So we're very happy to see that fiscal note that was added to our bill.
If anyone had any doubt about our commitment to this, or us putting our money where our mouth is, tacking that on to our bill, we were in support of it and part of the workshopping and building it, but they couldn't find a place for it. And as we just explained, there was a lot of other really critically important pieces of that. And we tacked that on knowing that it could have been controversial and could have killed the whole bill. Fortunately, it didn't, and the whole thing went through, and that, again, amongst other successes, was a big deal this legislative session.
And I think the other one is Assembly Bill 454. The beauty of that is it sets aside where it clearly states that if our department, the appropriation made by the legislature and the general fund is insufficient to cover the maximum contribution formula, that we can go to that statutory contingency account and they must refill that so that we can make the counties whole. It also allows our department that opportunity through our board on indigent defense services to set the hourly rate for indigent defense services in counties with a population of under 100,000 people. So to set the hourly rate in counties with a population of less than 100,000. And it allows us to set the statutory rate for post-conviction cases across all of Nevada. Because what we're hearing from the judiciary is that it's hard to find attorneys that are willing to do those cases at the $100 an hour. So we're hoping to address that hourly rate as well.
Well, the rate hasn't been changed in the statute since 2003. And one of the things that we had our data analysts do was a study on cost of living, overhead, and he looked at what $100 in 2003 was currently, and it came to about $163. So people are still doing this work for $100 an hour, and it's not sustainable. Again, there's that buzzword that I like to use, but it's sort of like the frog being boiled, right? All of your other expenses are going up for your office, for salaries, for payroll, for rent, everything else, and yet this rate has stayed static. So we're pretty excited to bring that in-house and kind of correct that so that it's more sustainable.
And I think the one thing that I'd like to add is, the judiciary is an important part of this. And what we hope is that the judiciary, if they see attorneys in front of them that need additional training, or if they see attorneys in front of them that they think are really great attorneys and they want to let us know, we want them to know that the phone lines are open. They can call us. They can email us. We would love to come and talk to them about concerns that they have and what we can do to make the system better in certain ways. So we're listening. We want to let them know that we're open to that. We're open to extending these communications. So that's one thing that we're hoping with this podcast is that the judiciary or members of the judiciary will know that, this is an entire team kind of working together. It is one system that's so important to keep sustainable, and bringing public defenders to that table and trying to be a voice for that. We're making such positive change, but we really need all players involved. And I think we're listening. We want to hear concerns. We want to know what we can do to make it better. That's part of the reason we're here today.
Definitely. I mean, again, as I've explained, our time is limited, and we've not been able to go out and sit in the offices or chambers of everyone we want to. But the judges that we have built relationships with, they know that the phone lines are open, and they call me, they email us, and it's, anytime they have a question or a problem or what do I do about this, or I've got this attorney that's a problem, it's not showing up, or whatever it might be. It's really easy to address if they know that the lines of communication are open.
Well, we have a website. It is
dids.nv.gov. This is one of Marcie's catchphrases. We love to talk about our website.
That's awesome.
Just extending on the website, we do have a board on indigent defense services that has meetings every quarter. We have a listserv that notifies individuals of when those meetings are. If you would like to join our listserv, it's on the Contact Us page of our website. You can also see the information that we're going to be discussing at our upcoming meetings. Every quarter, we take the data that we're collecting from our attorneys, how many hours they're spending, how many cases they have, how many cases they're closing, what the close reason is, and we're publishing that on our website. So if the judges would like to see what the attorneys in their county are doing, they can look to that website. We have an annual report, which is on our website, and it kind of sums up everything that we've done in the last calendar year. It touches upon what we've done at the legislature, our successes of working with the counties, and the fact that we received an award this year. Did you want to just touch on that a little bit?
Yeah, we didn't talk about that. The Public Interest Law Association, PILA, at the Boyd School of Law presented us with a Silver Embrace Award, and it's to honor an unsung hero doing good work out in all of the communities in Nevada. And so we were nominated apparently by people in the legal system at large for this award. And so I went down and received it. It was a great honor. We love working with Boyd as well. Making those connections and being honored is a nice thing. The last thing I would say is that for anyone that wants to be on our qualified list to provide indigent defense, the application is also on our website. What's that website, Marcie?
Oh, dids.nv.gov. So if you know attorneys that are interested, please send them our way, because we are trying to expand the list. We have over 100 attorneys on that list right now. We're open to more.
That's awesome. Well, congratulations on
it's the PILA Silver Embrace Award.
Silver Embrace Award. That's amazing. Really appreciate you being here today and sharing all the work that you're doing for our Nevada courts. We're going to go ahead and close out this podcast. Thank you for joining us for All Allow It Nevada.
Thank you.
Thank you.
Thank you for listening to this episode of All Allow It Nevada. Don't forget to submit a certificate of attendance for listening to this podcast to jepodcast@nvcourts.nv.gov. You can also send any episode topic ideas to that same email. Please join us again next month for another episode of All Allow It Nevada.